繼續。
Thank you. Let's continue with the public hearing. Mr. Lam, shall we give the floor to Tanya first, to be followed by Mr. Lam, and then you will cover the rest of part 4, and then we skip to part 6, and then the FSD and then the Buildings Department can be excused after answering the questions. Thank you, Chair. I want to ask a question about the case of Long Bin. I think it's a very special case. This is because, if I remember it correctly, it was in 1984. So, can you elaborate? Long Bin was completed in 1985. So, can the department explain? Albert? Thank you, Chair. Thank you, Member, for your question. We are talking about the Long Bin interim housing. For the office building, it was part of the former Long Bin Pt2. It wasn't demolished and it was retained to be used as an office. Therefore, the design and the construction took place in 1984. Sorry. So, for the former Long Bin temporary housing area, the design and the construction took place in 1984. For Long Bin interim housing, it was commissioned in 1985. So it was sort of in the transitional period.
The design was done before 1984 and population intake in 84. So, in situ ACMs were used. Do I remember correctly, starting from 1984, HD banned the use of ACMs for construction, for public housing construction. You referred to that transitional period. When was it? Thank you, Ms. Chen, for your question. In 1984, the decision by HD was for newly designed PRH estates after 1984, asbestos should not be used in the design. And for design that have started or when construction is in progress, for better utilization of resources, they would continue. But for projects on the drawing board, ACMs should not be used. Tanya, were there other cases during the transitional period? Because the ban was imposed in 1984, you already knew the serious health impacts of asbestos. So how come you still proceed with ACMs for projects being designed? Was it because Long Bin was planned to be an interim housing? Mr. Lee, no, we will not have different treatment for an interim housing. To assure members, this so-called transitional period, apart from Long Bin, in 1989 and 90, in the survey done by consultants, it was found that no similar conditions were identified. And in the middle of this year, we did another survey, and there were no other development during the transitional period. Can I follow up, please? So, looking at the document, you decided to proceed. Did you consider the health impacts on residents? Now, these people are the needy group in society. So, did you decide in the meeting that there was no need to take care of the health? When the decision was made, did you consider people that would be affected? You used the money to make that decision, did you have other considerations? Can you show us the relevant documents? Because this is an important issue. Thank you, Chairman. We can supply the paper to you after the meeting. Yes, please. Your justification was because it was at that transitional period, but it was not good to the residents. You have to give us the justifications. You have to understand, now, as Mr. Lam said, that you have to understand your duty and how to safeguard the tenant's health. May I supplement a little bit? In fact, even before the law was enacted, HA set this threshold for ourselves. It doesn't matter. I'm sure you have justifications. Show us the justifications. Although it is a policy, but from PAC's point of view, we are concerned about the use of resources, but we have to weigh it against health impacts. Well, if people suffer physically, then resources will also be involved, because there is the pneumoconiosis problem, and we are using resources to help people suffering from pneumoconiosis. Well, in 1984, it was in the design stage. There was still time for a change in materials at construction. Secondly, have you done any tracking survey on the health of residents? The answer is no. So you are a very smart chairman. I'll move on to another part, Chairman. Para 9, 4.9. Oh, about that 10% or 5% damage. I'd like to know whether you are going to review whether this method of survey can be improved. Albert. Thank you, Chairman. I repeat, our guidelines and manual were devised together with the EPD and LD. We see no room or no need to revise it now, but of course we do not rule further tripartite meetings. Ms. Chen. Well, the condition survey, paragraph 4.9a, localized damage and scattered damage. I think the condition is quite bad, because let's talk about damage exceeding 10% of the total area length of that ACM unit, and also for some is 10% and the other is 5%. I'd like to know when these thresholds were devised. When was the guidelines devised? Yes, I understand. As far as I understand, we must have some criteria, and they've been adopted by the three departments all along, and even in 2016. And this year we commissioned a consultancy to check the external areas and the flats as well, and they were experts in this area, and they were still adopting the same standard. As Albert said, we will catch up with times, and if experts have revised the guidance for us, we can adopt them. In paragraph 4.6, we can find the answer to Ms. Chen's question. In 1984, we devised the procedures and the guidance. Now, the amount of asbestos in ACMs can be 5 or 10 or 20%, and is mixed with concrete, unless the ACMs are broken or damaged, the risk through day-to-day contact is not high. And as for the corrugated cement sheet, well, it was not inhabited. But para 4.9, there's mention of 10% or 5%. There's para 4.9a. Here it says that the HD conducts half-yearly condition surveys and has laid down the following guidelines for staff. I'd like to know whether the guidance is the outcome of the 3 tripartite meetings or just by the HD. So I'd like to know who laid down the guidance. The guidance was laid down by 3 departments. Where can we see this? They're going to give us supplementary information. Yes, they were agreed to by 3 departments, but the guidance was made by you. Is that right? Am I correct in saying this? You consulted the other 2 departments which agreed to such conditions. So it's not the decision of 3 parties, rather it was discussed and agreed to by the 3 parties, and then you issued the guidance, right? Well, the process involved meetings of 3 departments. Any suggestion by experts would be put to the meeting, and they would be confirmed and agreed to before they can be put into the guidance. The guidance came from you, not the 3 departments, right? Strictly speaking, you're correct, Chairman. So you believe it should be guidance issued by the 3 departments? We have to ascertain or clarify this, because there is the question of responsibility. Allow me to supplement, please. Yes, there was suggestions or recommendations by consultants, and then it was included in the tripartite working group. The working group agreed, but of course, for guidance to frontline staff, it must come from HD. That's correct, because we have to be very correct. But the guidance is based on the agreement of 3 departments. Yeah, okay, I just want to confirm that, Director. I think that would do. Perhaps my comprehension is poor. So that 10% or 5% was confirmed at the tripartite working group. Am I correct? Yes. Since 1997, they had 38 meetings, so that was one of their decisions. Confirmed, Chairman. Para 4.21. I asked about the different tiers of inspections. And this is quite surprising revelation. For some units, within 6 years, there was no survey report, and for Heng Hwa Estate, in the interim, there was no Form 04 submitted. Because if no Form 04s were submitted, then RDU could not check. Would there be more senior level staff to check whether inspections were done? Because you won't know whether inspections were ever done, because there was no Form 04s. So how can you ensure the in-flat inspection has been done? And do you have more senior ranking staff to supervise or to ensure that forms were filled? Do you have such a system, and will you improve it? Now, for 4.20 in-flat inspections, indeed, there was no requirement on staff to report this. But if after 2009, if staff had the opportunity to go in flat and saw such things, they could reform. So we had 266 cases, reported cases, and 265 cases with no defect. So afterwards, we're asking them to submit such forms whatsoever. And that's why for 6 years there was no report, because first there must be the opportunity to go into the flat and defects spotted and reports made. So this is a fact. Well, without any report, would that mean that we wouldn't care? But in fact, 4.28 is that we have a senior estate surveyor responsible for the RDU. Once such forms are received, he would check the FO4s. Even if forms were not received, he would randomly select flats to check in 2009, 2015, 2016. From time to time, inspections were done, and we have this 3-tier system. And in para 22C, we've shown that at different times, consultants were asked to conduct random checks. Ms. Chen, do you have further questions? No more. Mr. Lam Chuk Ting. Thank you. I'd like to follow on the question of Long Bin interim housing. It is said that after 1984, ACMs were banned for the construction of PRH. But then the director of housing said that it was not what that meant. For housing developments already designed, they will continue to use ACMs. So I'd like to ask the director whether that was the case. Well, according to information from the HD, it was not as detailed as set out just now. We're just told that the ban was introduced in 1984. Yes, ban. Director. In table 9, we have notes 1 and 2. Note 2, we said that according to the authorized drawing provided by the HD, the design of Long Bin temporary housing area was approved in August 1984, and according to the HD's press release of July 1985, construction of Long Bin was completed at that time. So we told, it said that there was a ban in 1984, and yet it was used in Long Bin. We'll go and check what happened at the transitional period. It's quite shocking to hear the decision back in 1984. You already knew that asbestos was carcinogenic. You thought that by changing the materials that would cause delay and perhaps cost escalation, but that is incomparable to lives that might be lost. So you did not put the health of tenants in the first place. Your decision was, well, since it was already designed, it could be used. It gives us the impression that you were oblivious to the health and safety of tenants living there. So go back and check the records and tell us why or how come there was such a ridiculous decision. Very well put, Mr. Lam. But that's not fair to the director, because prior to 1990, they were not yet directors, or not yet imposed. So I think we should ask them to give us the historical records. We can only comment using nowadays standards. We cannot blame them, or not blame them, but we cannot ask them to answer such questions. Director, do you have anything to supplement? I think you've made a very clear direction, Chairman. We'll talk about 32 years ago. We have to check first how staff and also HA members consider that. When 1984 was a difficult time, that there was the reunification talks, and there was some turbulence. But let's ask them for the records. Okay. The deputy director said that the decision was made even before the law was enacted. Deputy director should think twice whether it is reasonable to say so. To me, it is not. You already knew that it was carcinogenic. Even though the law was not amended yet, you could not say that since it was already designed, ACMs could be used. That's not a reasonable argument. Yes, it is good that you have made that decision before the law was enacted, but you cannot use that as a justification and say that you had already done your best, that you're trying to be flexible to allow ACMs to be continued to use. That argument was not sound. I think the DD was trying his very best to answer your question, but in fact, it was not a question for him. He should go back and check the records, because when we consider such cases, is a bit to ask them to answer a question about the past. I'm sure I understand Albert's view.
We are not trying to find an excuse on behalf of colleagues, our predecessors, some 32 years ago. So even the HA stance at the time wasn't that the law doesn't prohibit and it doesn't stop me from doing it. As Chairman said, we need to investigate what the historical reasons were. We're not here to explain on behalf of our predecessors. Well, yes, when you answer, I have to filter through the answers. Yes. Continue. I would like to summarize, and then we can have the Housing Department respond. When we identified asbestos in PRH, for example, the Audit Commission mentioned that in the report, it gives the public an impression that the thinking 30 years ago and 30 years later is very similar. It seems that you don't pay a lot of attention to PRH tenants who live in asbestos-lined PRH. You don't attach importance to workers that work there. You also don't attach importance to leftover effects of asbestos. You said that you have to inhale asbestos over a long term to have any risk to health, and the damage, even if it's exposed, it doesn't have a large impact unless you're inhaling right next to it. So it gives the public the impression that you are underestimating and trying to downplay the effects. So I'd like to ask Mr. Ying, in retrospect, if tenants live there and workers work there, they would have a health concern. Even you say there isn't any impact. So if you were to live there, your relatives work there, are drilling, doing maintenance and repair, you would have concerns. So would you adjust your thinking? Otherwise, I think 10, 20 years in the future we'll have similar incidents occur. And lastly, I'd like Chairman and colleagues, should we issue a letter to EPD, the LD, and should it be the Health Department? How large is the impact of asbestos in this circumstance? And are the HD guidelines sufficient? especially in their daily operations, their inspections, labeling, repair and maintenance. You might have some procedures, but would there be a big shortfall in actual frontline work? Yes, Mr. Lam, what you said is very reasonable. The EPD, the Labor Department, they need to explain their role in their handling of asbestos over the years. In their 3 department meetings, they need to explain what their role is, how did they handle these situations. We will write to the relevant departments. So, Mr. Director, do you need to respond? Because that would help us draft our report. Chairman, let me respond on 2 levels. The Audit Commission, it covers work over the decades, so we need to understand the background and respond. So, as Chairman said, and it's also my view that our perceptions have changed over the years, and the legislation has changed. For example, we ban imports and so on. So I feel at the time, from 1989, the Housing Department and our 2 other departments in the consultant, we spent a few years to deal with that, because we attach importance to asbestos, because as legislators said, there's an impact on tenants and workers. So in hindsight, is it something that we could have done better? This is something that we always have to think about. Regarding health advice, I didn't want to respond too much because I'm not the responsible department, but I don't want to give people the impression that I'm downplaying it or underestimating it. So if you ask the health department, or we can get authoritative advice from health department. Now, regarding a mentality, every person in this post, they have to consider the situation. We have deployed the consultants. We've looked at the data and statistics. There are some things that we want to do. So if Audit Commission has some views where they think we can do better, I'm willing to explore that. So in 4.46, the Audit Commission has commented on some statistics that we've compiled. The Housing Authority also has a building committee. We will take on board those comments, and the most important changes are inspections inside the units. Previously we had done external inspection. We feel we can enter the units. And regarding value for money on design, we need to give the tenants information. They need to be reminded because they are in contact with the asbestos. So we need to enhance our transparency. As I said just now, if members have other considerations, we can investigate that. The affected tenants and workers' health. Will you be responsible for their health checks? I think that is part of their follow-up work. We can refer that to the relevant panel. Now the director can answer if he wishes to. Otherwise, we will refer to the panel. I just want to give him an opportunity to take responsibility. So when we draft our report, we can also consider his remedial actions. Well, why do I ask whether the secretary has can be in attendance? The director is only a civil servant. He's not an accountable secretary. I don't want the director to answer. I don't want the PAS to answer. If you can answer if you wish, but we will submit this or refer this case to the panel. They can follow up. Well, I have collected some information. I can respond briefly. Territory-wide, there is a pneumoconiosis a work group that deals with this. Since I'm a layperson, I understand that it takes a long time for it to be latent. The whole Hong Kong government has an arrangement. There is legislation and a fund. There are some health services, medical services. I cannot elaborate because that is not my ambit. That is the pneumoconiosis. They have billions of dollars. It's either 6 or 7 billion to deal with these situations. So if necessary, we can write to that committee. There is a policy in place, and but he's not the person to answer. So we now enter the 6th part. We'll deal with the 5th part later. So this part 6, I'll defer to Mr. Leung Kai-Chiang. I just want to ask one question. In paragraph 6.15a, Roman numeral 1, it says the interdepartmental meetings with the BD and the FSD had failed to reach agreement on the vetting formal acceptance of the HD's fire safety improvement proposals after rounds of discussion. So I'd like to ask the directors of BD and FSD, where's the difficulty? What's the argument? Why are they not able to reach a consensus since 2008? It's 9 years, 8 or 9 years. So I'd like you to explain to the public. So which director? BD or FSD? Director of Building? The fire safety ordinance is to enhance the fire safety of old buildings. So before the enactment of that legislation, all buildings, according to that time, they were designed according to the building standards of the day. So it doesn't mean that before enhancement works, their fire hazards are unsatisfactory. But since the enactment of the legislation, starting from 2007, the BD and FSD being the authorities, that they issued fire safety notices to the buildings to enhance fire safety. The BD regarding PRH, they are affected by the legislation, but this PRH, we need to handle it separately or differently. What's the difficulty with PRH? Well, there are a large number of them, and they were built to certain templates. We have template estates. There are 7 of these templates. In Appendix M, we mentioned the 7 templates. Third, these estates, when the law was enacted, the BD and FSD still didn't have the building plans, because when they were rented out to the housing department had its own arrangement. There were different repairs and maintenance, and the plans were still being amended. So based on that situation, you have to understand that given such a large number of flats, we need a suitable plan to conduct our enhancement works. So BD FSD from 2008 regarding fire safety enhancement, we've been in discussions, and one arrangement was that unlike handling private buildings, put simply, in private buildings, the first round of inspections would be done by BD and FSD. They would send staff to inspect the private building. They would create a checklist and then issue a fire safety notice. And they would give the owners time to do improvement works. But in PRH, we reach an agreement. The housing department will engage a consultant where there's an orderly inspection, and subsequently they would examine how to enhance fire safety. The legislation, when they refer to enhancement of fire safety, so in buildings department, we require the standards to be up to the 95, 96 level. But there are 3 areas, including escape routes, fire structure, such as the walls, the wall thickness, and third, we also have rescue access. Now, FSD, they will handle fire installation, so that is how we divide the work. The agreement we have with BD is that they would be they would conduct studies in different phases. They would see how to enhance, how they could enhance safety effectively, because housing department building designs are different from private buildings, so they might not be able to comply with the guidelines 100%. So they need to consider alternative measures. In the Audit Commission report, it's also mentioned that under the legislation we have set up some fire safety consultative committees. The committee will look at the process. So all this takes time, especially initially when the scheme was introduced. We identified 2 estates. The housing department identified Ping Sek Estate and Fuqua Estate because they represent 2 different template designs, but they make up a large percentage. They make up some 63% of these types of estates. So the consultative committee went through many rounds of discussion. They reported back to the housing department. So that process takes time, and as far as I know, these 2 early estates and enhancement works basically have been approved, and the housing department is undertaking the work. For the other 5 types, the work is still ongoing. In paragraph 6.13, the Phúc Loi Estate and Ping Sek Estate have already completed the remedial works. And the latest information indicates that Wache Estate has also been approved. So we have 3 schemes that have been approved. And Butterfly Estate and Tai Hing Estate and Tai Hang Dong, the report has been received by Buildings Department, and this opinion has been submitted to Housing Department. So it's underway. So Mr. Lam's question about 6.1, paragraph 6.15, what has not been approved or where we don't have a consensus. It's when all the works are completed, how do we conduct an inspection, and how do we approve of the works? It's hard to reach a conclusion because we need to examine the whole estate. We have to see whether there's a shortfall with the standards. We need to put forward remedial measures or alternative measures, and then we have to conduct the works. And then when everything is complete, we have to conduct assessment. My understanding is that after 2008, the final assessment, we were not able to reach our consensus on the final assessment. But I'm happy to report that the 3 departments have reached an understanding, and the BD and FSD, when the remedial works for PRH are complete, we will see whether they are in compliance with the fire safety ordinance and the relevant ordinance. Thank you for the explanation.
So you.
What about the DFS? Well, I think it is in line with the need for efficiency. If we are to adopt such a model, we have regular meetings among the 3 departments to follow up on the progress. In relation to the template, we are sort of trying to discuss the details so as to make sure that we can meet the statutory requirements. So the 3 departments have been trying hard to upgrade the work. Now, of course, we cover many different buildings. Once we have decided on the template, then when we roll out the program, the progress will be quick. BD, anything to add? Yes, we are talking about 7 standard block designs, and we started with Phúc Loi Estate. For Phúc Loi Estate, when we received the first enhancement program up to the time of final acceptance, it took 3 years. For the second one, that is Ping Sek, I think the time taken was about 2 years. And then in the case of Wache, we spent less than a year's time. Looking ahead for the remaining estates, since we have accumulated experience and the cooperation and communication among the 3 departments are good, so it will only be quicker and quicker. But then, of course, the scale of the project is huge, and we may need to plan the actual implementation. Mr. Lam, anything to add? No, thanks. For CAP 572, it has taken you 9 years, and you have explained why it took 9 years. Please tell us the following. Of course, we don't differentiate among the need for safety or the need for safeguards on the basis of classes of the members of the public. You did explain to us that a lot of work has to be carried out, but have you ever considered the well-being of the tenants? It's lucky that we haven't got any major fires, but it's still unfair to the tenants. Yes, they do live in public housing estates, but there is still a safety standard to adhere to. So are you actually saying that you are more relaxed about the safety requirements for PRH tenants? And that's why it has taken you 9 years? I think Mr. Lam's core question hasn't been answered. Well, the Director of Buildings gave an explanation it appears to me that the issue isn't really that complicated, it isn't really that controversial. So I cannot quite understand why it has taken that long. Why it took that long for you to reach a consensus. However, since you have already reached a consensus, and please actually tell me when was that done, Director of Buildings. I checked my records. That hinged on the understanding of the concept of self-compliance. Well, in fact, PRH requirements are different from the private sector requirements. Instead of having the two departments enforcing the law by way of inspection, the HD will have its own consultants, and then the proposals are handed to the consultative committee. So the arrangement is different from that for the private sector. I think probably it is a matter of the formal acceptance that lacked consensus. As to when we arrived at a consensus, since we haven't actually reached the formal acceptance. However, as a result of the latest audit report, departments had a meeting, and we believe that for law enforcement agents, we could not sort of stay away from expressing our views. So we sorted out the problem. Please answer Mr. Lam's question. When did you reach the consensus among the three departments? When? This year? Would it be after the publication of the Director of Audit's report? Does it mean that you reach a consensus in the course of the investigation by the DFA? It doesn't matter. We just want to go after the facts. Director of Fire Services, let me supplement one point first. Now, we are working on it. We haven't reached the stage of formal acceptance. When the Director of Audit studied the matter, indeed, at that time we didn't have a consensus, but we do have one now. End of last year, we had a meeting. That's the first point. Second point is that not too long ago, the chairman talked about the safety requirement. Well, for this ordinance, it doesn't mean that there are safety problems for those completed before 1987. They meet the fire safety requirements. We just want to enhance the fire safety standards. For this particular piece of ordinance, since the enactment of the ordinance, the HD has already enhanced the fire safety installations, like the fire resistant doors, etc. So all in all, as far as fire safety construction and fire service installations are concerned, yes, it is a fact that there are still items to be followed up. Now, DFS. Now we have got CAP 572, and the private sector has to follow the requirements. On the other hand, the HD can do it on its own. So 9 years, as Mr. Lam has asked, does it mean that it took you 9 years to reach consensus? It shows that you haven't actually enforced the law. So why have you allowed this to happen? We don't know about the scale of the impact, but I'm afraid it is a matter of executing the administrative requirements. You have asked the electrical to enact the law, but how come that you have got exemption and then it's only 9 years later, then you become aware that you need to form a consensus? We're not criticizing you, but we just want to know why this has happened. Now, for the PRH sector, we're talking about 780,000 units, and a lot of people live in the PRH buildings. Half of the population actually live there, and they should be given the safeguards under CAP 572. As I have said, safety is the same for everybody, irrespective of your class or your wealth. Mr. Chairman, I think you are right. The more they answered, the more questions I've got in mind. Now, as to which department will be responsible for formal acceptance, there hasn't been a consensus. Is it that the HD would get either the BD or the FSD to accept formally, and you are not willing? Or if you are asking the HD to do that, which director? It doesn't matter, all the 3 departments are there. Let them sort of have a break. Well, on page 104, Chinese version, the then director, that is my predecessor, attached a lot of importance to this matter. And then he said that our department do not agree to have the self-compliance approach. So the HD's position is that we'll do our best, but eventually we'd like to ask the 2 departments to give an approval in some form. But I agree very much with the then director's judgment. That is, make submissions to the BD, FSD for the vetting as usual. Well, I've read the documents. The departments were able to do what my predecessor has wished. That is, there was a discussion among the 3 departments, but it didn't hold back the 3 departments from working on the 7 prototypes. On my part, my understanding is that from the point of view of the HD, yes, I know that in 2013, the Director of Audit came up with a report on the implementation of this ordinance as then to be corrected. For the landowners in the private sector, there is a schedule 1, Schedule 3, so we are supposed to meet the requirements under those schedules. And then the BD will also issue instructions, so we just follow the instructions. As the 2 directors have said, the HD would like to be more proactive. Rather than waiting for instructions to come from the 2 departments, since we have got so many units, we have got so many complexities, we'd rather get our own consultant to work on the prototypes. And then we invited the 2 departments to comment. And then sometimes there are alternatives. Now, we have got an advisory committee, and then the advisory committee should comment on our proposals if they are different from the legal requirements. We want to be sure that what we are doing is right, since we are talking about huge housing stock. It involves public money. If we are to do it afresh, it means tenants will be affected once again. Let me make 2 more points once again. We haven't held up any work, and as the directors have said, we have already reached a consensus. The templates are propping up, and they include alternatives that we have to consider. Once they have been approved, and in fact we have already agreed on the formal acceptance. Yes, thank you, Director. We understand your point. We are still interested to find out why it's taken 9 years. It's not a matter of criticism. It's a matter of resources. If it is due to resource constraints, and so you are not able to do it so smoothly, then it involves, since it involves or jeopardizes public safety, then we would like to have this point reflected in our report. Don't think that we're trying to blame you. We just want to dig up the facts. 9 years are indeed a long period of time. Mr. Lam, do you have other questions? Yes, just a final word. The impression that I have formed is as follows, and I invite departments to comment. It appears that a few children are arguing with each other who should do the house chore until the parent asks who will take up the job, or if they don't do it, they all will be punished. So I get the impression this is what happened. Mr. Lam, we have to look forward. Now the 3 departments currently are willing to take up the job, so it is something good. Chairman, Well, we're talking about things that have happened so such a long time ago. Well, the boys have been doing the work. They are still sort of sweeping the floor, wiping the table, though they are still having a discussion. Mr. Kenneth Leung, if I may ask a question about a detail. Now, for the FSBO, in paragraph 6.6, it is said that in July 2007, the ordinance came into effect. Just now, I have been told that both Mr. Zhang and Mr. Li have said that the purpose of the ordinance is to enhance or to upgrade the facilities in areas like means of escape, etc. Now, we have 215 estates. If they are completed post-2007, I want to know whether they need to carry out the works involved so as to meet the requirements of the FSBO. Who will take this question? Mr. Hui? Well, for CAP 572, it is targeted at pre-1987 buildings. In other words, anything completed after 1987, basically they should be in compliance with the latest requirements. Now, for post-1987 public housing blocks, what about the means of escape, width of corridor, etc.? Which two or which three departments are responsible for the final acceptance? BD? Well, in the case of private sector, it's the BD that's responsible. In the case of the public housing, the relevant departments like the HD, and then in the case of the government buildings, it is the job of the ASD. But basically, we are using or applying the same standards. In other words, post-1987 buildings, say for example, post-1987 public housing estates, it would be the HD that will be responsible for the final acceptance in relation to fire service installations, right? Mr. Ying, would you like to answer the question? Yes, Mr. Ying. I'll try. For the professional parts, I stand to be corrected. I said this before, and the chairman is aware of it. For the HD buildings as well as government buildings, the building ordinance does not apply. Nevertheless, we would like to develop our own system so that in effect we are following the requirements of the BO. Therefore, under my post, that is Permanent Secretary, we have a coordinating committee that would mirror the implementation of the BO. In other words, newly completed buildings will meet the prevailing standards. Well, in that case, Chair, I want to know, now of course we're talking about the FSBO, how many estates are being affected among the 215? That is, those completed before 1987, how many of them? Mr. Ying? Thank you, Chair. Let me answer this question. For those affected by this piece of legislation, that is, those completed before the 1st of March 1987, there are 64 housing estates involving 460 blocks. All right. I know that 5 blocks have been chosen. In fact, there are 7. In addition to Fook Estate and Pingshat Estates involved in the pilot scheme, which was started in 2013 and 2014. 2013 for Fook, 2014 for Pingshat. I'm on page 123. And after that, 5 more blocks have been identified to be included in the pilot scheme so as to come up with a prototype. Now, for the D of A's report, I think it is mainly on the progress of Pingshat and Fook estates. What about the latest position? I want to know whether they have been finally accepted in relation to the fire services enhancement. It seems that they haven't. I want to know what is holding it back. So I'm interested in the case of Fook Lai Estate and the case of Pink Shack Estate. Albert, thank you, Chair. Thank you, Member, for your question. The Director of Buildings have said that Fook Lai Estate was approved in 2015 in relation to the proposals in the template for Pink Shack again in 2015, and the works for the two estates have just commenced, so we haven't reached the stage of acceptance. The directors have said that we have already got a consensus and we're moving in that direction. Chair, can they not sort of elaborate on the consensus? What is the consensus? Do we have a document to prove that there is indeed a consensus, or is it merely a verbal sort of commitment? You have said that the consensus was only reached recently. Can you give us a paper, and can you verbally tell us what the consensus is about? If not, please give us a paper. Can that be done? Director, as other directors have said, I have talked to the other two departments. We have a way to sort of express or present it. But then for the audit recommendations in 618, it says here, to ensure that the fire safety improvement works for meeting the FSBO requirements in PRH estates are efficiently vetted and formally accepted. I think this is a very good way of presentation. Well, that's the audit's recommendation. I think you must have a paper showing the consensus among the three departments. Mr. Leung is asking for it. You know what we are talking about. We want to know about the consensus that you have reached. So please don't adopt the audit's recommendation in the report.
Which is asking for the documents, for instance, that interdepartmental working group, you had 7 meetings, and we were shocked. Well, anyway, you have recently agreed on a scheme. So can you give us a paper to tell us what it is so that we can include in our report? That is in relation to para 6.18. Is it okay? Do you have a question? No. Kenneth. I don't know what form that document will take, but looking at para 6.18, there is no clear division of responsibilities and which department should accept the works. Should be the HD, the BD, or the FSD, or all three of them. So I haven't followed the review of the fire services related legislation. Recently, we had talked about fire engineering, registered fire engineers, and will they be included? So let us look at the document first. Okay. Chairman, if I may continue. After Pink Shack and Fook Lai Estates, they've chosen 5 pilot points, or rather building blocks of 5 different designs. So for para 6.9D 5, I'd like to know whether they have covered all sorts of designs of the HD estates. We take a look at the information. The 7 types cover 400 odd buildings. There are 32 blocks left, and they are non-standard blocks. So they cannot be represented by these 7 typical samples, but the 7 will represent over 90%, not 67%. 67. Director of Buildings mentioned 67. have I got it wrong? Perhaps my colleague can supplement. The director of buildings talked about 67% because we want to make it very clear. So I heard 67% and you now is 90 odd percent. So I'd like to know what they represent respectively, because the director of buildings said it quite clearly. Yes, thank you. Let me supplement. Now, there are 7 types of blocks, but as the Deputy Director said, the 7th type represents a group of non-typical designs. And for I type, represented by Folkloy and Pink Shack, these two together cover 67% of the housing stock. And then Deputy Director mentioned 90 odd percent because we have non-standard blocks. They account for about 10%. So other than that, the rest would represent about 90%. Thank you very much for your explanation. So we're told that for Folklore and Pink Shack, the progress has been quite satisfactory. Do you have any plan to cover or to work on all these 67% these two estates represent? Well, you talk about 2 years or 3 years. Can you take this question, please, Mr. Hui? Well, we'll talk about the time to work on the submission framework of the sample flats. Yes, the time for that is slower, but then for the works is different. So do you have any target timetable for the works, Albert? There are 3 sample estates, including ward chair, and they are all approved. So the progress is now faster than it was said by Mr. Hui. And for now there are 7 types. 3 have been approved, and for the prototype they've been approved, and for the remaining 4 we have submitted them to the director, the buildings department for the last prototype. They will be submitted to the department later soon. So for those already approved, Folklore and Pink Shack, we do not just work on these 2 estates. They represent 20 odd housing estates, 67% of the PRH blocks. And then we will compare them against all the similar estates, and we will resubmit the design and plans. We have to work out a list before we can start the actual works in the housing estates. Because we have so much not yet done, we have to keep track of the progress, and we do not have a concrete timetable yet. Now, Folklore and Pink Shack, you are done with the 2. Now, if this model is to be applied to the other housing blocks, now you have a plan. Do you have to consult any advisory committee? Because if you do, that will be a delay of another 2 to 3 years, and this is rather appalling, because you have 60 odd percent. So once it is accepted, can you work out the plan and carry out the works as usual? Do you need a consolidated view from the HD HB and the FST? If yes, what will be the procedures like? Albert. For information, if we use information obtained from the prototype housing estates for application to the other housing estates, do we have to consider each housing estate individually? It depends on the extent of deviation from the prototype estates. There might be the possibility, but I defer to Mr. Hui. However, the possibility is not that high. Mr. Hui, we have to conduct overall examination of the prototype estates so that we can have a model for application to other housing estates. So if it is adopted in other housing estates, then there's no need to go back to the advisory committee. But if there is, in practice, some deviation from the accepted report, I don't know the need to go to the advisory committee again. But so the buildings department has put the ball back to the HD. So I think it should be for the HD to decide whether they have to resubmit it to the advisory committee for consideration. So HD, are you confident that you can do it? Do you have the expertise? Can you tell us now if you've considered the plans, if it is a standard approach, then you don't have to submit to the advisory committee again. If not, you have to do it. So can you say clearly whether you're going to be the gatekeeper there, Mr. Lee? Well, why do we have to be the gatekeeper? Now for the prototype estates, Fokoloi and Pink Shack, well, in fact, work done on them have facilitated our work in other estates. But for each and every estate we have to submit plans. Sometimes our challenges, constraints in already built housing blocks. Will the width or the height be sufficient? And if not, we have to propose a compensation for FSD and BD to consider. So it depends on whether comparing the prototype estates with other estates, there are special circumstances. If yes, we have to resubmit the plans. But if there is no special reasons for deviation from the prototype approach, then I think more or less it will be okay. Kenneth, I'm worried that because there are 3 buildings, the HD may not dare to say that there's a standard and there is no need for resubmission. And again, everything is submitted to the advisory committee, which may think that it's too troublesome. You're submitting 60-odd housing estates. So instead of a couple of years, they may take 3-4 years to complete the task. I just want to add a word of caution. Please do not drag your feet for too long, because you already have the prototypes. I hope you have heard my comments, and I hope you can proceed ASAP. Yes, I know fire escapes or fire exits and doors might have to be added, but among those prototypes, are major structural alterations needed to the extent that examination has to be done or approval has to be obtained? Yes, on page and picture 2, photo 2, figure 2 of page 127 shows that in old housing estates we have to build new fire-rated wall to protect the staircase, and after that, new fire-rated door has to be done, and we have to encapsulate some of the walls, and this will bring nuisance to residents. And while they are waiting for lifts at the lobby, ventilation is good. In future, it may not be the case. That's why our work is so challenging. We have to discuss with the EMAC of individual estates, and we have to discuss with them the progress, because we cannot just do it in the same way for all housing estates, and in some cases structural enhancement may have to be done. Thank you. Table 14. There are 3 different consultancy contracts involving the 5 samples. Are you talking about 5 housing blocks of 5 estates? I want to sort this out first. Can I invite my colleague, Assistant Director, to answer? Ms. Young. Table 14 mentions 3 consultancy contracts to cover the 5 remaining prototype housing estates, and then we have to do a submission for each estate, so they cover some of the remaining housing estates. But this is just a contract for the study, is not for the construction works. Is that right? Yes. Yes, that is the cost of the consultancy contracts, not the construction works. We have a few dozen housing estates to upgrade their 5 services installations to meet the statutory requirements. I'd like to know whether you have an estimate of the money required, and have you included that in HA's budget? Do you have such figures? Albert. I'll defer to my colleague, Ms. Young. Thank you. Yes, we do. We have budgeted for such works. The plans and the budgets have been submitted to the Buildings Committee under the HA, so we do. Chairman, can I invite them to take a look at the budget? Do we have to know their budget? You asked for a timetable from Albert, and he said no, there wasn't any. If he hasn't got a plan, how come there will be a budget? I hope that 5 years down the road I will still be here. I'd like to know whether there would be a big discrepancy in the outturn expenses. Now, Albert, you told us that there was no timetable yet, but that's impossible, because Mr. Leung has put it the other way, in another way. He asked you about the cash flow analysis or the forecast. I'm sure you must have a timetable for that. Director. All right, may I respond to Mr. Leung's altered question? In para 6.1, you can see that there were submissions to the Buildings Committee of the HA. It was financial information, but to have an accurate budget, we still have some way to go. So you told us, I think arising from his question, I'm sure they have a timetable. Please give us a time frame so at least we can have some knowledge. For non-standard types, there are 30-odd blocks, right? they will be more challenging. When are you going to see to these 30-odd blocks? Because as said by the chairman, tenants enjoy the same rights as they should, entitled to the same level of protection regardless of the types of blocks they live in. So I must ask for a timetable. After you have done with the standard blocks, then the non-standard blocks may have to wait for another 10 years, and that is unacceptable. Albert. Frankly speaking, we focused on the 7 prototype housing estates because they are very representative of housing blocks, representing and covering the greatest number of housing blocks, and our priority was to work on them first. Within December, from the HD's point of view, submissions would have been completed for all 7 types. So we are going to work on these 32 blocks afterwards. I hope that our pace can be fast, and we will do it in a gradual manner. One last question, Chairman. I'm not too familiar with the 5 services legislation. I think we are going to amend the ordinance to employ registered fire engineers. Can they examine and accept these FSIs on behalf of the FST? Is just for your information, for my information, because you don't have to tell us that you don't have enough manpower, because the BD may employ registered fire engineers to do it on your behalf. Director of Fire Services. Well, the amendment bill, Fire Services Amendment Bill, is being scrutinized by the Council, and for licensing and for checking and acceptance of FSIs, it will still be done by the FST. Thank you. That's what I want. So I know you will ultimately be responsible. I have no more questions. Any more questions?
Just now you said all the fire safety plans, and I'd like to ask, you have all the experts in the housing department, because in the short piling report, in the Legco short pile report, a problem was highlighted that you had a fiefdom, a silo approach, and there wasn't any coordination between the departments. So a lot of times when you execute or you enforce this type of legislation, the BD and FSD, do they have staff helping you? Just now you referred to a mirror, so is that the same situation? Chairman, in order to highlight the independence of this, it's operating independently from the housing authority. These ICU staff, they have a lot of communication with the building department. They will help us understand how BD enforces the building ordinance. And there are 2 consultants that were seconded from building department to the ICU. And the BD, the buildings director, and his senior staff will also participate. The housing authority also has some committee members. They also say that the ICU is very strict. I just want a deeper level of understanding. it's not. There is indirect participation by the building department because you have staff seconded there. The BD, the ICU, their staff are professionals, architects, engineers, surveyors, and we also have some staff seconded there working with them, and they share experience regarding vetting permits. Recently we had more communication. The ICU members would also participate in building committee meetings. They would see how we vet complex cases. The ICU and BD also has a high-level meeting every 6 months. The director and deputy director will conduct an in-depth review. So over the last few years, the cooperation between the departments is very intimate, and we are confident that the HA buildings are built according to BD standards. Oh, no questions. I had intended to end at 12:30, but thank you. Merry Christmas. Next occasion, we will deal with excess lead in water and part 5, the clothing pole, the clothing rack. Okay, thank you. Next occasion, BD and FSD don't need to attend. Thank you very much.
Okay, 唔該晒。